The second speaker on behalf of the respondent is welcome to take the floor. Please proceed.
Thank you. Madam President, Your Excellencies, may it please the Court. As earlier introduced, my name is Genevieve Wu, and I too act on behalf of the respondent, the Republic of Romania. I will continue the case for Romania on the third and fourth prayers. Beginning with the third prayer, the contention is about where the applicant's exclusive economic zone, or EEZ, is. And this turns on the question, as put by the International Law Association in their 2012 Sophia report, whether the baseline is a line on the chart or a line on the ground. In other words, whether the baseline follows what is illustrated on the chart, officially recognized by the coastal state, or it follows physical reality.
I really like this. It's a very clear exposition of the issue on ambulatory baselines. Clear, succinct, to the point, really easy to follow.
Now, the applicant has submitted that it is the former for the specific context of states preserving their zones in light of climate change. And they do so on three bases. First, that this is supported by the objecting purpose of the convention. Second, by an evaluative interpretation of the convention. And finally, by subsequent practice informing the treaty interpretation. And I will disprove each of these elements in turn.
Again, this is really clear. The speaker sets out the three submissions made by the applicant and says she will address each of them in turn. It's really helpful to the bench when a speaker is responsive to the submissions put against them and addresses them directly.
The oralist appears to commit the same mistake of sorts as the first applicant, because neither of them connects their treaty interpretation argument to a specific clause, thus lacking the element of wording that the bench highlighted so much with the first applicant. So where the first respondent managed to tailor her arguments much closer to what she considered what the bench needed, second respondent answers to the applicant, but might not be as successful yet as to focus the bench and focus her submission on the actual legal core issue, the main provision in question.
Starting first with the objecting purpose of the UNCLAUSE, it is clear that the convention was meant to create a stable regime for the law of the seas, but stability that is reached by a compromise struck by states parties to allocate their maritime rights to the extent that their land territory and their coast extends. In other words, the land dominates.
Counsel, sorry, if I could just back you up a little.
And just when the oralist wanted to present the famous wording by the ICJ of the land dominating the sea, President Donahue stops her. Let's see what the question is.
So you've indicated that you're going to start your argument with the object and purpose, but could you start instead with the text of Article 5 and help us to understand how you interpret that in light of the other considerations that are relevant, please?
So the bench still has the same yearning for the wording and now asks the oralist to exactly do something that, by comparison, the first respondent had usually offered on her own accord.
The text of Article 5 shows that the chart recognized by the coastal state plays an important role. But what it does not say is whether the chart determines the baseline or serves some other function, like evidencing where the chart is. So the text is ambiguous in itself. And that is why this court, to understand the text, has to refer to other elements of treaty interpretation in Article 31 of the VCLT, including the object and purpose.
Judge Donahue asked the speaker to start with the text of the treaty and how it's interpreted with the other considerations that she mentioned. In her answer, the speaker should have quoted directly from the treaty itself, because that is what the judge asked for. However, she paraphrased it and then moved on to explain why she was considering the other considerations mentioned in her roadmap. As a point of constructive criticism, it might have been better first to lead with the plain language of the treaty, explain how she would interpret it, and then explain why the applicant's three interpretive considerations were wrong.
The object and purpose closely relates to the fundamental principle that the land dominates the sea. In other words, it is the coast that is the source of the maritime rights of the state, and this principle has been repeatedly recognized in these courts.
I would like to ask you a hypothetical question. Let's assume there would be a volcano eruption on the coast of a state that has submitted a chart. And this volcano eruption would result in 400 meters of additional territory to that state. Where is the baseline?
Judge Nolte asks a hypothetical question of where the baseline is when there is a volcanic eruption after a state has submitted its charts. But the eruption, in this case, adds 400 meters of additional territory. Such questions are typical in the Jessup and are designed to test the logical reach of the speaker's argument. So a Jessup team should always be prepared for these type of questions.
The chart or the new territory?
The baseline would follow the new deposed territory that has been added. And I know this also pertains to a question raised by Madam President about situations where rather than land receding, land might be added to the territory of the state. And we submit that the position to be taken that is principled and consistent is for, in either situation, for the baseline to follow the physical reality. So if the land moves in, the baseline moves in. If the land moves out, the baseline moves out.
Quite clear in logic and wording. The issue here is there is not necessarily any law. Yes, presumably the agent is still applying Article 5 of the Law of the Sea Convention, but she doesn't point it out to the bench. Thus, her argument seems to be one that is made in general or in abstract, and potentially this creates the danger for her that both applicants at times suffered from a bench that tends to get lost with too general statements and then will ask questions sort of leading to a back and forth about what the actual argument is.
This was also recognized as a consistent position by the ILA in their Sophia report. And this is also consistent with this court's jurisprudence, where it has looked behind the charts deposited by the state to determine the geographically accurate coastline of the state, as, for example, it has done in its 2007 Caribbean Sea decision between Nicaragua and Honduras, as well as the 2001 maritime delimitation case between Qatar and Bahrain.
In response to the hypothetical, the speaker remains consistent and says that the baseline should follow the physical reality. She gives a very simple, easy to understand formulation. If the land moves in, the exclusive economic zone moves inward. If the land moves out, the exclusive economic zone moves out. She then closes the loop effectively by citing to the ILA report as well as other cases that support her position.
And because this is a long-standing position of the UNCLOS, what the applicant is suggesting that there is a permissibility for the fixing of baselines, and such a deviation from that long-standing practice will go against the object of preserving stability and certainty, where states knew for so long that all they had to do was to look to the physical reality.
The speaker notes that the applicant's fixed baseline approach would result in instability and uncertainty. This cuts against the object and purpose of UNCLOS, which is to provide certainty and stability. Nicely deployed argument.
Counsel, how would you reconcile your position with the principle of permanent sovereignty over natural resources, which is inherent to the right of self-determination, which has been recognized as a peremptory norm of international law? So the stability of maritime areas, which allows the applicant to continue exploiting the resources that are in its exclusive economic zone, is consistent with that principle of permanent sovereignty over natural resources. How would you reconcile that with your position?
Judge Ribeiro asks how the speaker's position can be reconciled with the permanent sovereignty of natural resources, which he says is a corollary of the right of self-determination, which is a peremptory norm of international law. His point here is to show that if the baseline follows the actual waterline, then states would lose the right to exploit the natural resources in a portion of their EEZ because it would shrink, again, if the waterline goes backward. This is a really good question. Let's see how she handles it.
It would be consistent insofar as the entitlement of the applicant to natural resources within 200 nautical miles of its coastline has not changed. It is entitled to that same amount. But that is quite different from saying that the applicant can continue to assert entitlement on an EEZ that no longer belongs to it, but belongs to the high seas for every other state to fish on the natural resources. And this is quite similar to how the idea of historic rights is something that is not codified in the UNCLOS, and as made clear by the Permanent Court of Arbitration in their 2016 South China Sea case, that principle of historic rights is overridden by the allocation of rights based on zonal systems like the EEZ in the UNCLOS.
The speaker gives a good response to this question. She acknowledges that states could lose entitlements, but the state will always maintain entitlement to natural resources located within 200 nautical miles. She then makes a nice analogy to historic rights, but such rights would not override rights created in zonal systems like the exclusive economic zone. This is probably the best answer to the question that she could give. It's a small quibble, but it could have been deployed a little bit more efficiently.
Counsel, if we go back to Judge Nolte's hypothetical, think about that. A new peninsula is created. That's one scenario. Another scenario, more relevant to this case, the land mass shrinks. The state prepares new charts and submits the new charts to the United Nations that correctly, let's just assume correctly, indicates the low water line. Shouldn't those charts be given relevance? They're accurate, they're reliable, hypothetically available, informative to the world. Why isn't that the way forward?
I'll address those several points in turn, Madam President. First, to get to the relevance of the chart, we do not submit that a chart is completely irrelevant. They are important as presumptively accurate evidence of where the chart lies, or where the coastline lies, my apologies. But that is quite separate from saying that the chart is the be-all and end-all of where the baseline is. That is made clear by the Travaux Préparatoires, where when drafters stated that when it is proven by evidence that the chart is inaccurate, then it is subject to challenge by another state before a court or tribunal, as mentioned in, for example, the 1954 and 1952 fourth session of the ILC at pages 171 to pages 178.
In response to Judge Donohue's question regarding the submission of new charts in light of a change, and what weight should those charts be given, the speaker correctly points out that the charts are still relevant and could serve an important function, but that it could still be challenged. When challenged, it's the actual low water line that governs, which supports her position that the physical reality is the critical analysis. What I like about this, too, is that she wasn't perfect with her answer, but she moved along as if nothing happened when she tripped over a few words. Because her recovery was so smooth, her minor slip-up didn't draw a lot of attention.
And as for, Madam President, your second point about, Madam President, could you please remind me about the other relevance of the chart that you mentioned?
This is a good example of it being perfectly okay for a speaker to ask a judge to repeat or rephrase a question if they haven't heard it properly or haven't understood it. It's perfectly okay to do that, and that's exactly what the speaker does here.
I was just asking you generally what the relationship is between the part of Article 5 that speaks to the low water line and the part that speaks to the charts. I think you may have answered my question already, so I think you can go ahead.
Thank you, Madam President. And on this note, I would like to address a point made by the applicant, again, that states can simply choose whether their baselines are fixed or ambulatory. And Madam President had asked, how do states know the position of other states?
Here is a good example of referring back to a question a judge has asked. In this case, it's the president asking of the applicant how other states are supposed to know where the baseline is. It's a nice touch. It gives the speaker an opportunity to put the respondent's argument on this, and it shows that they are paying attention to what the bench is interested in.
Indeed, they do not know first whether other states' land had receded or expanded. They have to check it. And not only that, they do not know what the position of these other states are in relation to fixed or ambulatory. This means that a state will have to constantly check with every single other state what their legal position is, and that undermines the object and purpose of legal stability and certainty under the Convention.
This is a really good argument for taking a single approach to baselines, that is, that they are ambulatory. It's a good common sense argument that would appeal to a bench.
Could I take you back to my questions about treaty interpretation, if I may?
So if you focus closely on President Onyu's questions, it is the repeat leitmotif of treaty interpretation, and specifically Article 5. Something that the agent is not necessarily doing, and the repeat question, in my view, indicate that here President Onyu was ultimately not yet satisfied with the answer that contained many correct arguments about the law of the sea in general, but were overall not satisfactory in terms of a proper treaty interpretation under the Vienna Convention on the Law of Treaties.
So there are varying arguments one could make about what we know about the positions of various states. But let's just assume that we're a few years ahead, and let's just say that, say, 140 states have indicated, have either asserted a mobile baseline or have taken the position that such baselines are consistent with the Law of the Sea Convention. So then how, under the Vienna Convention on the Law of Treaties, how does your state take stock of that growing agreement, apparently, of the parties to the treaty on a particular interpretation of the treaty?
That turns on the question of whether there is sufficient subsequent practice that establishes an agreement of states parties about the interpretation of the term under Article 31(3)(b) of the VCLT.
But the ILC has also said that partial subsequent practice under Article 32 may play a role.
So if you could address both of those, please.
I'm supplementing the President's question.
And that is true, Your Excellency, although the ILC did say in its 2018 draft conclusions that practice between a limited number of states can be considered under Article 32, although that carries less weight than that under Article 31(3)(b). And I note that the threshold of practice under 31(3)(b) requires all states parties to have either engaged in the practice, or if they did not engage in the practice, to have accepted the practice of other states. And I note that this is something mentioned in the 2018 ILC Special Rapporteur 5th report, which I know Your Excellency was Special Rapporteur of. And
It seems that you're not the only person in the room who's aware of that.
In response to Judge Nolte's question regarding whether the views of states could still play a role despite the lack of any subsequent agreement, I think the Speaker was salivating at the bit to answer this. She correctly identifies the distinction between Article 32 and Article 31, and then she's able to know that this is something that the Special Rapporteur mentioned in the ILC report, which in this case was Judge Nolte. It was perfectly deployed. Sometimes little things like this that results in some fun and laughter can turn a very close round. It can't be forced and has to happen organically, as it did here. Very nicely done.
Let me take you back to Article 31.
Yes.
Let's assume that we don't have any, let's leave aside the supposed persistent objector argument. Let's just assume that that's not of interest to this court. And we have a large number of states in the 140 range, and others have said nothing or, as was suggested earlier, reserved their position. At what point are the conditions in Article 31 regarding subsequent practice? At what point are those met?
If it's the situation that 140 out of 170 states parties to the UNCLOS have taken that position, then we can accept that, assuming that the remaining 30 have accepted the views of the 140, then a new understanding has been accorded to allow states to fix their baselines. But that is not quite the situation, actually, based on the submissions of states parties to the ILC. And I note that Judge Nolte had asked agent for the applicant whether there were 2 or 3 states who mentioned that this is merely something that is an emerging norm or something that is unclear. Now, there's not just 2 or 3 states. In fact, there are at least 24 states who have expressed views to this effect. And just to name a few, this includes Thailand, the United Kingdom, Cuba, Tonga, Malaysia, states in Europe like Romania, Poland, South America, Argentina, Chile.
Back to Judge Donohue's hypothetical regarding whether the conditions of Article 31 are met, assuming that 140 out of 170 countries agree with this fixed baseline position. The Speaker makes a very nice concession, assuming that the remaining 30 have accepted or tacitly accepted that view. Then there would be a subsequent agreement on the interpretation of the treaty. But then she wisely points out that this is not the case here, as some 24 states have actually opposed it. Unlike the applicants in their submission, the Speaker puts the number up front, which catches the attention of the judges, and then she proceeds to name the countries.
Sorry, what was the first state you mentioned?
If I can name one state submission, for example, that of Iceland, it stated in their submission to the UNGA in 2021, and I quote, that it was too early to comment on the precise legal implications of sea level rise for the convention, end quote. And later in 2023, it stated on behalf of the Nordic states that there is an important difference between saying that there is no obligation to update the charts under the UNCLOS and equating that to saying that baselines are fixed according to the charts.
When pushed, the Speaker gives the example of Iceland, but I'm not sure this is the best example.
This view...
Does this mean, if I accept that situation, but would the court not, if it would accept your position now, arrest a development of international law, which a large majority of states seem to be pointing to, and a small minority not really objecting to?
In response to Judge Nolte's question regarding whether this position would actually arrest the development of international law, I don't think she really answers the question. She seems to mix up fixed and ambulatory baselines, which is probably inadvertent. Then she talks about a long-standing rule, but she doesn't address the heart of the question of whether this would prevent the development of international law. These type of questions are difficult to answer, but it's important to listen to it and to try to figure out what's the best way to respond that is still consistent with your position.
Well, that is an important concern if the position was that baselines were always fixed and there's a small troublesome minority that is opposing that position. But the reality here is that the long-standing position is that baselines are fixed. And what the applicants are seeking to do is to change that long-standing legal status quo in favor of a fixed baselines approach. Therefore, it is not just a question of a few states who are opposing, but quite a sufficient number, at least 24, as I've mentioned, that have expressed a view similar to that of Iceland, which I've cited. And to address the final points on the evolutive interpretation, I note that Judge Romez Gobledo had asked whether there is a fundamental change of circumstances here. And as
Actually, Judge Gomez had not asked whether there was a fundamental change of circumstances here, but much rather whether this was something the applicant would like to argue, and applicant declined. So from a strategy perspective and the considerations on how the agents use their time, this seems to be something of a strange move to actually engage in this discussion. And it can also be risky because with a more active bench, the oralist might risk getting follow-up questions on the fundamental change of circumstances in general that she potentially is able to answer, but those answers will not help her advancing her argument because this is something of a detour that she willingly took. Let's see how it plays out, though.
The agent for the applicant has rightly pointed out, there is no fundamental change that it seeks to invoke here. The question remains whether it can rely on the change of circumstances to dynamically interpret Article 5 of the UNCLOS.
The speaker brings up a question brought up by Judge Ribeiro regarding whether there was a fundamental change of circumstances. I'm not sure I would have raised this, as the applicant conceded there was no such change. That being said, I understand why the speaker raised it, which was to set up her argument that a change in circumstances generally can't be used to justify dynamically interpreting the treaty. This then leads to her position on treaty interpretation.
But this court has set out requirements for applying that doctrine in its 2009 navigational and related rights case, including that the term interpreted must be generic. But here, Article 5 is not a generic term. In fact, it is a carefully constructed provision when seen in light of its neighboring provisions like Article 7(2), which provides for straight baselines method of drawing the baseline. That provision is important because it specifically provides for the chart recognized by the state to remain permanent, irrespective of subsequent regressions of the coast. And the presence of such an exception in Article 7(2) means that drafters had contemplated the possibility of fixed baselines, but excluded it for the purposes of Article 5. And an evolutionary interpretation would cut against that intention of states parties.
So now the second respondent's arguing that Article 5 of UNCLOS does in fact have a particular meaning. She describes it as a carefully constructed provision, and that the meaning is not evolutive. But in answer to the President's earlier question asking her to locate her submissions on Article 5 in the realm of treaty interpretation, the Speaker responded that the wording was ambiguous, and then went straight back to her submissions on the object and purpose of the Convention. So the two answers are not entirely consistent, and the President might be thinking that too. Also at this point, she moves to her final submissions, leaving only 5 minutes to deal with that last declaration on the seizure and sale of the aircraft, which is perhaps cutting it a bit fine.
Turning then to address the final issue, concerning the seizure and sale of the Falcon.
The speaker completes the answer to a question and then transitions to her fourth submission after a pause. This is another effective tactic of being able to move your argument along. However, her time management is probably the worst of all four speakers. She moved to the last submission after spending the better part of about 17 minutes on her first issue, thus leaving only about 4 minutes left for her final submission.
We agree with the applicant that the central question is who was the government of the applicant at the time. Where we disagree is on the applicable test. The applicant has submitted that the only requirement is constitutional legitimacy and not effective control. But we submit to the contrary, that effective control is the only requirement.
Not exactly the argument of the applicant. The applicant had a twofold argument, firstly relying on constitutionality and then an alternative argument dealing with the effective control test and the criteria for effectiveness not being met. It's interesting that the bench let this slide. The other thing that is interesting in terms of choice is that the bench appeared to have been leaning much more towards questions regarding effectiveness, and yet here the agent seems to be much more willing to engage the point of constitutionality that the applicant potentially wasn't entirely able to fully develop because so many questions dealt with effective control.
But to first understand what is the correct test for determining the government of a state, we must begin with the purpose of such a test. And the purpose is to identify who is capable of causing a state to comply with or violate international law.
As the speaker begins her fourth submission, she appears to be more reliant on her notes. She still maintains good eye contact, but she's going back and forth between her notes and keeping her eyes on the judges. I thought she was stronger in this regard in her third submission, so I thought that this was an interesting contrast.
And that,
Excuse me if I may interrupt. So what you're saying is governments in exile are irrelevant.
they are not, Your Excellency, they are not irrelevant insofar as we are concerned with the conferral of official recognition, which carries with it political and normative dimensions, as has been done, for example, by the UN's Credential Committee.
In response to Judge Nolte's question regarding whether governments in exile are irrelevant, the speaker uses some language talking about how government recognition carries normative value. This gets her into a little bit of trouble, as you'll see when Judge Ribeiro questions her about this.
But what we are concerned here with is not official.
Sorry, counsel, are you saying that official recognition carries normative value? Did I understand correctly?
It does.
Well, then tell me, do you know about any rule of international law, either universal or regional, that gives, that obliges a given state to seek and get and obtain recognition for that state or that government? It can apply both to state and government.
So again, we see this pattern on how this bench reacts when the foundation, the basis of the argument, is not quite clear, when they have not been pointed towards what the core issue is. Because a couple of seconds ago, the agent mentioned recognition, and now suddenly she has to enter into a series of questions with Judge Gomez regarding the importance or the value of recognition. And did you notice how the question specifically asked for any rule of public international law, indicating that maybe also the legal basis had not been established clearly enough in the pleadings so far.
Is there a rule that obliges that state or government to seek and obtain recognition for that state or government to be considered as a legitimate one?
We submit that there is in fact no obligation, whether internationally or regionally, for states or governments to seek that kind of recognition, although we accept that there are elements of statehood that are well established under the 1933 Montevideo Convention, which are not in question before this court.
As to Judge Ribero's question regarding whether recognition carries normative value, the usual understanding is that it typically is a political decision as opposed to some legal right to be recognized. Initially, she responds that there is some legal right, but Ribeiro follows up and asks her to identify a rule that obliges states to be recognized. Then she has to backtrack. This illustrates the importance of being precise in your use of language. This got her into a little bit of trouble. Perhaps it was inadvertent. If so, she should have just acknowledged that she misspoke.
But as for the recognition of governments,
Slovenia and Ambrosia are part of a group of states which have signed the OCDP Charter, the first article of which says that they intend to protect the rule of law and our democratic institutions. Now, even if the court would say, okay, under universal law, effective control is determinative, would we not have to say these 7 states are a democratic community and they cannot just accept the exercise of raw power and follow the exercise of raw power?
This question by Judge Nolte is actually helpful because it guided the oralist back from the recognition discussion, which really wasn't necessarily that important to her main argument. And instead, now, when answering Judge Nolte's question, the oralist can actually go back to her initial roadmap and further explain what her argument is and more thoroughly bring it forward.
Well, Your Excellencies, I can see why Article 1A of the Charter prima facie seems to cut against the recognition of the Council. But if I were to invite this court to consider the ambiguity about the meaning of the rule of law here, and the question raised by Judge Nolte earlier about whether the fact of the matter is that the constitutional precedentary of the applicant state has not changed. It has not changed before the Council was established, and it has not changed during the Council's administration. In fact, the Council made it clear that once President Derry was able to assume office, it would dissolve immediately, and it did so, as promised at paragraph 55 of the facts.
The Speaker, in response to Judge Nolte's question about Article 1's reference to democracy, makes a nice concession that it arguably cuts against the recognition of the Council. But the Speaker turns it around in her favor by pointing out that the other phrase in Article 1 regarding the rule of law helps them. She then references Judge Nolte's earlier query to the applicant regarding whether this is an issue of illegality versus constitutionality, and points out that the constitutional president has always been President Derry before, during, and after the Council. I thought that this was a really good answer to a difficult question.
The other reason why I say the OCDP Charter supports the recognition of the Council by the respondent is the second part of Article 1A as well as Article 1E. Article 1A in its second part points to democracy, which does not expressly stipulate for example, democratic processes and elections, but points to the substantial need for substantial democracy. And we would characterize that as giving effect to the will of the people or the right to self-determination, which is a right enshrined in the ICCPR, which both states are parties to.
As a follow-up to that answer, the Speaker then further substantiates her point with another good reason. She notes that the OCDP Charter references democracy, but doesn't specify the form. Rather, democracy at its core must recognize the will of the people, and clearly the people by and large supported the council. She further notes the will of the people is inherent in the right of self-determination. The Speaker thus grounds her argument in a more authoritative legal principle.
There are compelling, yes.
You are aware that the argument of real and substantial democracy has been used and abused, and that there is a certain danger with that argument.
There are certain dangers with that argument. I note my time, Madam President.
Please go ahead and finish the answer to that question, and then your time will be up. Thank you.
Thank you.
This might be a simple thing that doesn't need a lot of explanation, but the Speaker did well to acknowledge the expiration of her time immediately, and then ask for permission to answer. She just didn't assume that she would be allowed to answer. Normally, when a speaker's time has elapsed during a pending question, the judge will allow you to answer. But you still have to stop and acknowledge that your time has elapsed, which is what she did here.
The reason why it was not used in an abusive interpretation here was because there were compelling reasons for the council to have assumed power.
The agent here applies a safe strategy because Judge Nolte asked one of the bigger questions, this doctrine, has it not been used and abused, and it's a dangerous argument in itself. And the oralist does not follow him there on this abstract level, but rather deals with a factual pattern in order to demonstrate that at least in this specific instance here, no abuse happened, which in a way is potentially effective. On the other hand, it is slightly more deflective of the question than addressing the core issue. Bearing in mind that the time had run out, maybe better a safe strategy than no answer at all, or an ensuing discussion after the stop sign.
Now, not only do we see that the Zavalan administration dealt with the natural disaster inadequately, and that there were violent demonstrations against her administration asking for Peretes to assume rule, we can also see that the Transitional Council did as it's promised to return the power back to Derry when it assumed office. This concludes my submissions, and may it please the court.
Thank you.
Here, the Speaker used about 30 seconds to answer the question after she was given extra time. This is probably the outermost that you could get away with. This is just my opinion, but usually you will want to answer a lot more quickly, preferably in 20 seconds or less. The answer here bordered on being a little too long.
Overall, I liked this speaker the best. She did misunderstand or mishear a couple of questions, but in terms of pace, manner, clarity, I thought her submissions were the easiest to follow.